Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer in Alabama. And what I want to chat with you about in this video is if you've been sued, is it a mistake to talk to the collection lawyer about settling the case? Is that an admission that you owe the debt? Is that an admission that you owe exactly all the way to the penny of what they've sued you for? Or can you freely discuss settlement without having bad effects in the lawsuit? So it's basically there are no bad effects, but let me give you some pitfalls, some mistakes that people make. So first of all, general principle, when we have lawsuits going on, litigation going on, the law and the courts do not have a problem with us talking. So when I sue a mortgage company, I sue a debt collector, I sue a trucking company, whoever it may be, there's no discouragement for us to talk about settlement. So how does the law do that? Well, the law says that anything I say to the company on the other side, anything they say to me, that's confidential. Okay? That can't be brought up in front of the jury. In other words, let's take the typical collection case. So you're sued by Midland Funding for $5,000. And you talk to the collection lawyer about settling your case. And you say, I'll offer you $3,000. And they say, nope, we're not going to take that, but now we got you because you admitted you owe this debt. No, that's not how it works. And I don't know of any judge that would allow them to even start talking about that. So if during the trial they go, well, you know, Judge, they called me on the phone and offered $3,000. Judge say, hush, I don't want to hear about that. We're not here talking about settlement because that's supposed to be confidential in the sense that it doesn't come into evidence. Okay, so, and it works the other way. You know, if they say, look, we sued you for $5,000, but if you'll pay us $3,000, we'll settle with you. You can't go, aha, that proves you were lying when you sued me for $5,000. It doesn't work that way. Because again, we want parties, the plaintiff and the defendant, to talk about settlement. So, I said, in general, there's no problem, but there are some pitfalls. What are the pitfalls? Well, here's what happens. You get served with the lawsuit. And whether it's a debt buyer, original creditor, whoever it is, you say, look, I'm going to settle this case. So you call the lawyer and you're talking to the collection lawyer and you make an offer. And they say, well, I'll get back with you. 2 days goes by. Well, now it's the weekend and now it's 5 days and it's 8 days and you were sued in small claims or district court. You have 14 days to respond. And on day 8, the lawyer calls you back. And, you know, you offered this much and they're way up here. And you say, well, let me think about it. So you think about it a couple of days and you come back to them with a counteroffer. And now we're at day 14. And they say, well, let me think about it. And so it's day 15 and day 17 and 18. And you're waiting on the response. So you don't file a lawsuit because, hey, we're talking. We're trying to settle this. And all of a sudden, you find out there's been a motion for a default judgment. And they say in there, look, we served him 18 days ago. He has done nothing to defend himself in court. Therefore, enter judgment for this amount. And you know what? A lot of judges, boom, that's entered. You now have a judgment against you. You say, wait a minute, but we were talking. They say, hey, we can talk, but you still have to file your response. So that's the biggest danger, is that you just assume, and it's a common sense thing. If I'm talking to this collection lawyer, it seems like I shouldn't have to file in court, but you do have to file your response in court. So here's the solution. If you want to talk to the collection lawyer, do that and file an answer. So you have to protect yourself. Kind of think of it like defensive driving, okay? So you may say, well, the fair thing would be that they would not go to court and say, well, you know, this guy hasn't done anything, this lady hasn't done anything. They would tell the court the truth that you are talking, but they don't have to. And your obligation is file an answer. So file a response in time. You can file a response and still talk to them. Okay, it's not like you have to choose one or the other. And my suggestion to you is don't just choose to talk and not answer. Now, you may just want to answer and say, I don't want to talk. That's totally fine. You may say, I want to file an answer and I want to talk. That's totally fine. Just don't do the deal where you call them on the phone and time drags by, whether it's intentional or whether it's not intentional. Keep this in mind. these debt collection firms, they would file hundreds of lawsuits a week. They have thousands and thousands of lawsuits. And it's probably unlikely that the collection lawyer remembers your specific case. And so everything is automated. So you get to day 14, no answers filed. Day 15, day 16, boom, it's going to trigger, just the computer will generate the default. And then the lawyer looks at it, and the lawyer, she may have a whole stack of these. Just, yep, sign and sign and sign. And not remember that, oh, 2 weeks ago she spoke with you. So protect yourself. File your answer and then talk if that's what you want to do. So to answer the question, because we get this a lot, is, am I hurting myself by talking to them? Well, you're not hurting yourself from a trial standpoint. I will say this, though. If you think you're going to hire a lawyer, so let's say that you're thinking about hiring my firm, I would rather you not talk to the collection lawyer, because you may make an offer and they reject that, and then you come to me and my offer is going to be much less than what you offered them, okay? And so that puts the collection lawyer in kind of a difficult psychological spot. If you offered them this much and they turn it down, and then we offer them nothing other than not suing their client, or we offer a smaller amount if it's an original creditor, then how do they explain why they should take that? So my suggestion is, as you go through, and we have a ton of videos on this, your 5 options. You can file bankruptcy, you can fight it on your own, settle it on your own, hire a lawyer to fight it, hire a lawyer to settle it. If you're thinking about hiring a lawyer, my suggestion is get with that lawyer before you call the collection lawyer and find out, is this the right lawyer for you? Do you like the strategy that's being offered? Do you understand the price? Does the price make sense to you? And that way, any settlement negotiations will just come from that lawyer, rather than you may be saying something and then your lawyer comes in and says something different. So that's my suggestion to you. But the biggest danger is you're talking to the collection lawyer and not doing anything else, and boom, you get a default judgment. You can think of it like there are 2 trains, and there's the litigation train and the settlement train. And these are on 2 different tracks, and they run independently. And whichever gets to the station first wins. So you may file your answer, that's a litigation, but if you settle it first, that's great, no problem. But if you don't file the answer and you're just talking about settlement, that litigation train without you is going to get to a default judgment. So just be very careful about that. And if we can help you in any way in Alabama, it's 205-879-2447 or alabamaconsumer.com. Thanks for watching this video, and I'll talk to you soon. Okay, bye-bye.